The title of this talk is In the Beginning, and it's appropriate not only, I think, to talk about the preamble of the Constitution to start off a series like this, but it's also, I think, neat to have a talk like this, not because it's going to be fabulous, but because it is about beginnings, and it is about how we begin to understand the Constitution. So this talk, this mini lecture, is called In the Beginning. During a smallpox outbreak in 1902 in Massachusetts, the state of Massachusetts, along with 11 other states, passed a mandatory vaccination law that required all adults and children to be vaccinated against smallpox. But claiming that he had become ill as a child and fearful that his 3 small children would fall ill again to the smallpox vaccination, a man named Henning Jacobson, who was a Swedish immigrant and minister in Boston, refused the vaccination and also refused to pay the $5 fine that went along with refusing it. He was arrested, charged, refused to pay. Eventually, his case would come before the Supreme Court in a case called Jacobson versus Massachusetts. That case wouldn't come for 3 more years. The arguments that he developed, though, are what I want to talk about in this lecture for why he did not think that this state law, this mandatory vaccination law, was constitutional. His first argument, well, his general argument, was that this in some way violated his liberty that the Constitution guaranteed to every individual. And the first place that he went to find the word liberty in the Constitution and therefore use it constitutionally was in the 14th Amendment to the Constitution. The 14th Amendment to the Constitution was passed after the Civil War and in the wake of Reconstruction. It was designed to reassert national power over states. But the way it did it, though, was to limit the actions of states. And it did 3 things. It did many things, but we want to talk about 3 things in particular. The first thing it did was it said that states could not violate your privileges and immunities as American citizens. The second thing that it said it couldn't do was what Mr. Jacobson was concerned about. It said that without due process of law, we cannot take away your liberty. It also said that states cannot deny you the equal protection of the laws. So here was the first place that Mr. Jacobson found a constitutional avenue with which to argue that his liberty was violated with this Massachusetts law. But he went a step further. He said, but wait a second, the preamble to the Constitution, the first set of words and sentences that we read that introduce the document before us, that he read and that we're going to talk about throughout these lectures, contains the word liberty as well. And it does. In fact, the document or the preamble is as follows. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. But 3 years later, when the Supreme Court heard this case in Jacobson versus Massachusetts, they not only rejected Mr. Jacobson's argument that the act was unconstitutional, but refused even to consider that the preamble to the Constitution contained any source of rights. Writing for the court, Justice Harlan argued that, quote, and again, this is what Justice Harlan is saying for the majority of the court, saying that the preamble is not even an acceptable argument that we will consider on behalf of Mr. Jacobson. Justice Harlan said, quote, although the preamble indicates the general purposes for which the people ordained and established the Constitution, it has never been regarded as the source of any substantive power conferred on the government of the United States or on any of its departments. Such powers, Justice Harlan went on to argue, embrace only those expressly granted in the body of the Constitution and as such as may be implied from those granted. He went on to say, although one of the declared objects of the Constitution was to secure the blessings of liberty to all under the sovereign jurisdiction of the United States, no power can be exerted to that end by the United States unless, apart from the preamble, it be found in some express delegation of power or in some power to be properly implied therefrom. The only rights secured or powers granted to the government then were those explicitly laid out in the main body of the Constitution itself. Justice Harlan effectively rendered the preamble as nothing more than a pretext or an introduction to what was to come in the written Constitution that followed immediately after the preamble. Interestingly, this is the only time in Supreme Court history that the court considers the preamble to the Constitution. And it's not that people haven't made arguments before, but this is the only case where the court answers the question of whether the preamble is as binding on the government as the rest of the text. But despite the court's unwillingness, I should say, to consider the preamble's meaning, there are three important concepts that I want to talk about that are central to a proper understanding of American constitutionalism that I would argue that any informed citizen should know. Again, I want to read the preamble so we're absolutely clear about the words and the clauses. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Let's consider the very first clause, or even the first three words then. We the people. The phrase we the people stands in stark contrast to a phrase that some of the potential framers and those in the various ratifying conventions would have preferred. And that phrase was we the states. In fact, in the Virginia ratifying convention, in other words, after the Constitution was written, each state called special conventions to decide whether or not they would ratify the Constitution. In the Virginia ratifying convention, Patrick Henry, of Give Me Liberty or Give Me Death fame from the Revolutionary War, stood in front of his colleagues and said, how dare the framers, or those who wrote the Constitution, use the words we the people instead of we the states. In fact, Patrick Henry was to go on to vote against the Constitution. Many patriotic Americans were very afraid of the new Constitution and afraid of a concentration of power. And that's exactly what Patrick Henry was afraid of. Let me read the clause very quickly again, and we can see or get an idea of what Patrick Henry was afraid of. We, the people of the United States, are going to do some things, right? We're going to ensure domestic tranquility, establish justice, provide or promote the general welfare, and secure the blessings of liberty to ourselves and to posterity. But what does that mean? Well, that can mean many, many, many things. It can be interpreted very liberally. It could be interpreted very conservatively. Right? That's what Patrick Henry was afraid of. That kind of capacious or large-scale meaning that the preamble potentially contained within those words. Those words sound reassuring and very nice to us when we read them. But to those at the time of ratification, they were potentially very dangerous because they were so potentially meaningful in so many different ways. So aside from Patrick Henry's concern about we the people, though, there's another way that I argue, or that we should all understand, what the term we the people means. And again, I want to put it in contrast to what Patrick Henry said the preamble should say, and that was we the states. Well, to say we the people instead of we the states signals a huge shift in legitimacy. What I mean by that is the same that the framers meant when they used the term we the people instead of we the states. The parties to this new contract that would come together and ratify, ordain, and establish this Constitution were not to be the individual states. They were to be the people in a national sense, not in a state sense. Individual states have their own provincial nature, their own parochialisms, right? Oklahomans think certain ways for the most part, and in different ways than other states. But Americans as a whole might think in a very particular way that may or may not be different from the way Oklahomans think. I'm not saying one is more more right or wrong than the other. But there are two different ways we can imagine who we are. The preamble says that the legitimacy that this Constitution will get will come from the people, again, not in their state characters, but in their national characters. So this document is superior to state governments. But more importantly, though, when we say that this document is legitimized by the people, we the people, that also means, or I should say that does not mean, that the national government eats up the states or takes the states away or does not or makes them disappear. The term we the people suggests not only that the people are stronger than the states, this national people, but also that this national people are stronger than the Constitution itself. Right? That's where the legitimacy and power comes from. The people as a whole, not the people in any state with those kinds of concerns. And the phrase, we do ordain and establish, is the third point that I want to make this morning. Unlike other constitutions, particularly England, which had and still does have an unwritten constitution, American constitutionalism took a risk and did something new. It wrote down, in writing, the rules, structure, power, and the rights that will form and limit our government. And that's what we can understand from do, ordain, and establish, that we're writing something down. And at its core, right, writing the Constitution, writing down what the powers are, right, what the rights are, what the structures of government are going to look like, what government can and cannot do. Writing that down serves many purposes, not the least of which was this idea that the Constitution was to be a higher law. Right? Do ordain and establish. The Constitution was to be a higher law. The preamble was suggesting that what is to come is something different than an ordinary act of the people. People act ordinarily in a governmental sense every day. We pass laws about taxes. We pass laws about registering our dogs in the city of Norman. We act ordinarily every day in every level or on every level of government. But this Constitution, to ordain and establish, make it a higher kind of law. If we pass a law that says you need to register your dogs in Norman and that fee will be $25, tomorrow, if we don't like that law, we can change it. There's a simple majority vote to make it $15 or choose not to register our dogs at all. But the preamble suggests that what is about to come, what is written down and is about to come, is something different than that ordinary law. It's a higher law. Right? Not necessarily a religious law, but higher law. Right? It cannot change in the ordinary way that law changes. It's a different kind of law. It's a higher law. Thus, when we combine the idea of we the people with the clause do, ordain, and establish, we not only understand, again, that this is presupposing a national character as opposed to a state character, but we should also understand that it's presupposing that the people themselves are higher than, right, in their written constitutional law, are higher than and superior to, right, the national government and the state government, or any state government. Thus, while the Supreme Court in Jacobson versus Massachusetts might not understand the preamble as legally binding, right? Jacobson lost. While the Supreme Court might not understand the preamble as legally binding, in the same way that, say, the First Amendment is legally, constitutionally binding, we can nevertheless understand the preamble as theoretically binding, right? And see it as a roadmap that frames and guides our unique experiment in higher lawmaking that seeks to ground its legitimacy in the popular sovereignty of the first three words, we the people. Thank you.
Freedom 101 is made possible by generous support from Woody Young, and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.